Thank you very much, Kamina, for this introduction, and members of the head table, ladies and gentlemen. I think I'm privileged to be present here today before you to speak on a topic which has attracted a lot of attention all over, and before an audience, erudite audience of the Kotalabla Defence University. I think with the new millennium and also with the changing world, law and justice has several challenges to meet in the new millennium. As you know, the difference between the domestic area and the international territory is fast diminishing. What we consider to be a sovereign state with all power is now diminishing because there is a lot of international focus upon the domestic affairs of any state. And what I wish to say is that I feel that in the years to come, that this is going to expand further, and the domestic arena is going to be constantly under the supervision and the focus of the international community. I believe it is a welcome move because with the expansion of international law was first considered to be a system of law that deals with states, but today it is expanding, its area and scope is expanding fast. As a result of that, today even individuals, international organizations, and most other areas have come within the focus and within the scope of international law. We also know of dualism and monism. We speak of dual states. Our own state belongs to one of them. Where we consider international conventions, we do not consider international conventions as our own law unless it is absorbed into our legal system by way of legislation. But we see a shift from the dualist approach, especially from the Commonwealth countries, the countries which follow the common law system, which were Sri Lanka itself was a colony of the British. As a result of that, we too inherited the dualist system, but today we see that we too are moving slightly towards the monist system where we consider international law with more generosity, where we consider international conventions, and we think that international conventions should be applicable to the legal system of our country, though we have not totally dissociated or divorced ourselves from the dualist system. So in a situation like this, the challenges that we are going to face in the future are tremendous. When I looked at the topics that will be covered by some of the lecturers today, some of those speaking at the sessions, I see that we deal with human rights. Human rights is an area where international focus is expanding very fast. As a result of that, human rights has become one of the most important topics ever discussed, and also topics which have concerned the international community in a big way. Today we cannot think of any form of international dealings without human rights coming forward. In the 20th century, what happened was there were institutions which dealt with international law, and those held states responsible for violations in those areas. Whenever an individual was to be treated for a violation of international law, international humanitarian law, a violation of human rights, it was always done by an ad hoc tribunal like the Nuremberg trials or the Tokyo tribunals. But now we see with the creation of the International Criminal Court by the Rome Statute, there is a permanent international criminal court imposing criminal liability on individuals in the area of human rights. I think this is a step that we have taken, a step forward, but unfortunately Sri Lanka has not ratified the Rome Statute yet. Though Sri Lanka has not ratified the Rome Statute, still we are aware of the international repercussions as far as human rights violations are concerned, where the International Criminal Court has jurisdiction to try persons if they cannot be tried, or if the local system or the domestic system is not in a position to try that person for those violations. This, I think, is a move in the correct direction, because human rights are considered to be during the Second World War, immediately after the Second World War, when the leaders got together in order to decide as to what steps they should take to prevent a third world war, they found that human rights violations were the root cause for the first war and the second war, and that was the beginning, and that was the commencement of the Universal Declaration of Human Rights. Commencing from the Universal Declaration of Human Rights up to the International Criminal Court created by the Rome Statute, I think we have come a big way, and that is going to be one of the greatest challenges in the years to come. Greatest challenges, I say, that wherever human rights violations take place or wherever human rights violations are highlighted, the international community is going to take the steps that they are available to take, that they are able to take in terms of the new provisions, including the Rome Statute, where the International Criminal Court was created. So what I believe is that one of the greatest challenges that we have to face during the new millennium, one of the greatest challenges in global law and justice, is the protection of human rights, fostering of human rights, protection of human rights, and guaranteeing of human rights to the citizens of your own country. This is one aspect that will be highlighted, and I see that there is a Ms. Vasanta will be speaking on this particular topic. I'm sure she will deal with this in greater detail. Two aspects that I see as areas where there will be a lot of developments and a lot of responses are the global environment, where there is a duty by the international community and the members of all domestic states to take every possible steps to protect the global environment. I will refer to you advisory opinion given by the International Court of Justice. This was about the use of nuclear power. There was a dissenting judgment by one of the Sri Lankan judges, Justice Veeramantri, where he said that the use of nuclear power would be illegal in terms of international law. The basis upon which he expressed his opinion was that the use of nuclear power is going to have a devastating effect on the environment, and that cannot be done because we have a duty, we owe a duty towards the future generations and also towards the members of the international community. If you read this judgment, of course it was a dissenting judgment, the majority judgment delivered by the other judges did not follow this same judgment, but in this minority judgment, he has highlighted the fact that it is absolutely necessary that we be mindful of the impact that nuclear weapons would cause on the environment. So this I thought I will highlight during the course of my speech, because this again is going to be one of the greatest challenges that we have to meet in the years to come. As you know, a lot of discussion is taking place about the nuclear weapons that have been used, about the nuclear tests that have been conducted by some of the countries, and whether they are acting in violation of the international conventions of which they are bound. So this area is going to be one of the greatest challenges that we have to meet, since nuclear weapons, the use of nuclear weapons has become, of course, I don't say that it has, at the moment it has become a threat, but in the years to come, it is going to be a potential threat, it is going to pose a potential danger to all mankind. As a result of that, it is necessary that we look at this matter in this new millennium when we speak of global justice, in order to prevent any activities taking place in those areas. Then another aspect that would be extremely important when we speak of the global environment, law and justice in the global environment, other than the protection of human rights, other than the guarantee of human rights to all, I think is where development comes in. Wherever there is development, they say that the development causes some sort of damage to the environment. There is a wonderful judgment. I would refer that judgment to you. That is the judgment of the International Court of Justice, Hungary versus Slovakia. Hungary versus Slovakia is a case in which the judges of the International Court of Justice discuss the importance of development. Devoid of development, we cannot think of moving forward. Therefore, development is extremely necessary. But in that particular judgment, two important concepts have been highlighted, and those two concepts have today entered into the judicial systems of the members of the international community, including Sri Lanka. The first is sustainable development. Sustainable development is something that we ought to take care of, because unless there is sustainable development, the development will be of no use. In this judgment of the International Court of Justice, specific attention has been paid to development and also how much it would have an impact upon the world's resources. I think it was long years ago that Mahatma Gandhi, when he was questioned on something, he said that the resources of the world would be sufficient to satisfy the needs of the people, but not the greed of the people. That exactly is what is highlighted in this judgment, where they say sustainable development in the process of development should be formulated by legal principles. The law should come in. The law should step in wherever they find that development is going to cause a problem to the resources of the world. This was a case where there was the dam was being erected, and they found that the damage that it was going to cause was immense. And when it was objected to, the International Court of Justice proceeded on the basis that there was no provision to object to the development where it causes some sort of damage to the environment. But what we ought to look into is to minimize the damage as much as possible and regulate such activities by legal provisions. So sustainable development is going to be a world concept in the very near future. It has gained ground already, and it is going to be something which is going to emerge as a concept that is absolutely necessary in the areas of development. Then the other area that I wish to concentrate upon is a new area which has been also highlighted in some of the judgments of the International Court of Justice. Now this is intergenerational justice. Intergenerational justice is that we ought to consume our resources having in mind the future generations. We are the custodians of the world of today. And when it comes to the world of tomorrow, we ought to remember that there is a generation unborn who will be entitled to enjoy, to consume those resources, who would depend upon those resources. And this very important concept of intergenerational justice has been highlighted, and it has been pointed out that unless intergenerational justice is accepted, and you have in mind intergenerational justice, what it means is that what would be of the future generation, supposing we do not have them in mind in our development effort in today's world. International law comes in all these areas. International law, devoid from domestic law, as you all know, domestic law, all our domestic activities are governed by our domestic law. But where it comes to international law, where we move away from dualism and we accept monism as one of the areas where international law must be accepted by the global community. In that attempt, I'm sure that the impact on human rights, impact on the natural resources of the world, and the protection of global environment are going to be of utmost importance. And when we speak of today's topic, that challenges and responses of the global environment, we are not forgetting the domestic environment, because within the domestic environment we take steps. But whenever we take steps within the domestic environment, it is absolutely necessary that we have in mind that whatever we do is going to have an impact on the global environment also. So as I stated at the commencement of my presentation, the concept of absolute sovereignty is today fast diminishing. The concept of dualism is also fast diminishing. And today we are gradually, we are going towards an international environment. An international environment within which there should be a place regulated by international law, in which a safer world would be created. A safer world not only for the generation that is living today, but for future generations to come. So ladies and gentlemen, I don't think I wish to speak more than that. There are many other speakers who will be presenting on these areas. So I present to you three important matters. Number one, that international law and the international community is taking charge of the global environment very fast, and we cannot any longer be within the domestic arena. Our domestic decisions should have some sort of impact, we should have the international, we should have some sort of idea about the international environment also. And the three areas that I see are firstly human rights, secondly the global environment, and thirdly the custody that we have of the environment and the resources, and the important concept of intergenerational justice. So with these words, I thank you very much for your attention.